Hey everyone, welcome back to the StudyTube Project, this time with me. For those who don't know me, I am Kieron and I have finished my second year reading law at the University of Cambridge. What I thought in this video I would do something law related, given that is what I'm taking at university, and I'm going to focus on the court hierarchy of the courts in England and Wales. What you'll see on the screen is a diagram of the court hierarchy in England and Wales. As you can see, it's quite complicated, quite an intricate system, but what I'm just going to do is go through each of the levels and just talk about what each court does, what kind of cases they might hear, what the purpose of those courts are. So to start off with the top court, and that is the Supreme Court. Now the Supreme Court used to be known as the House of Lords, and that's because they sat as a committee in the House of Lords until around about 2009 when they moved over to the Supreme Court. So they moved over to a new building across Parliament. If for those who have been in London, either living there or visited there, you might have seen it. I've certainly been inside of it. And the judges who used to be called Law Lords are now called Justices of the Supreme Court. And the purpose of the Supreme Court is they are the final court of appeal for all civil cases in the UK and for all criminal cases in England, Wales and Northern Ireland. Scotland has a different system in respect of criminal cases. And they only hear cases of public importance. You might have heard, for example, about the two Miller cases. The first Miller case was about whether the government could trigger Article 50 with the prerogative power, i.e. with like a governmental power, or whether it needed Parliament's permission, which they needed. And you might have also heard about the prorogation case last year, where the question was whether or not the Prime Minister had lawfully prorogued Parliament. So those are the kind of cases they hear, cases of constitutional importance, but cases of great legal importance, and they focus on the legal issues. Factual issues are something that we more dealt with in the courts below. The legal issues is what the Supreme Court will be concerned about. But as part of the Supreme Court, you've got the Judicial Committee of the Privy Council. Now they consist of members of the Supreme Court, but also judges from other Commonwealth countries sometimes, and that's because the Judicial Committee of the Privy Council hears cases from Commonwealth countries and from Crown dependencies, etc. And so they deal with some legal issues that come up in foreign countries where they have gone through their legal system and are now appealing to the Supreme Court, or in the form of the Judicial Committee of the Privy Council, to resolve that particular matter. So they are the top of the UK judiciary. If you come down one bit, you get to the Court of Appeal. And the Court of Appeal is, as the name would indicate, an appellate court, meaning it hears appeals. And there are two divisions of the Court of Appeal. You've got the civil limb and you've got the criminal limb, and again the labels would indicate what kind of cases they deal with. If you then come down one further, you've got what is known as the High Court, and the High Court consists of at least three main divisions. You've got the Chancery Division, the Queen's Bench Division and the Family Division. The Queen's Bench Division consists of a number of specialist courts that deal with particular areas of the law. So for example, the Queen's Bench Division has administrative courts, and administrative courts will deal with, for example, applications for judicial review. So if an individual wants to bring a claim against a local authority because they have abused their power, they have used their power beyond the purpose intended, for example. And the Chancery Division also includes specialised courts as well. For example, they'll have courts, or they'll deal with cases concerning tax or land or probates, for example. And the Family Division, as the name would indicate, deals with family law issues, marriage, divorce, but also the consequences, the financial consequences that arise out of separation of a couple, for example. If you move down one further, you get to the bottom tier, and these are normally the courts of what we refer to as the courts of first instance, i.e. these are the courts most of the time you'll be applying to first for particular issues. Now the High Court is also a court of first instance in some cases, but these courts are as well. One of these courts are the county courts, and these deal with civil claims, but more small value civil claims within the geographical area of that particular county court. So if the claim is of a higher value, then it would normally be dealt with by the High Court, for example. It wouldn't be dealt with by the County Court. The County Court generally only deals with low value claims. And another example is the Family Court. This was set up in 2014, and it replaced the Family County Court and the Family Magistrate Court to deal with a lot of the family law issues that probably be best served by a more specialist court. Turning to the criminal side, you've got the Crown Court. Now, the Crown Court is made famous by various television appearances, often depicted as a judge and 12 jurors, and that will often be the case. Most criminal cases will involve jury. 12 jurors, people selected from the community to decide on that case, with the judge to assist with any legal issues that arise during the trial. And the Crown Court deals with, yes, the cases of the more serious nature, so murder cases, for example, but it'll also deal with sentencing, and it will also deal with any appeals that come from the magistrate courts. Coming down one further, you've got the magistrate court, and the magistrate court actually deals with most of the criminal cases. Only the more serious ones, or the ones that have been appealed, will go to the Crown Court. And so the magistrate court deals with a lot of low risk kind of cases, deal with a lot of low level kind of crime, but they also can deal with what is known as tribal either way offences. And what this means is essentially the defendant would have the choice of choosing the magistrate court or the Crown Court to have their case heard, and there are numerous advantages and disadvantages to choosing one over the other. Of course, the court could decide that the case is better served in the Crown Court, even if the defendant thought it was better served in the magistrate court. Normally, cases in the magistrate court are dealt with by a panel of 3 magistrates, and the magistrates are essentially lay people. They are not qualified judges in the same way as a judge in the High Court would be, for example. But they are assisted by a clerk, and that clerk is legally qualified and will assist the magistrates with any issues of law that might arise in a particular case. A case could also be dealt with by a district judge or a deputy district judge, and they are more qualified and will deal with the more serious and more complex cases that wouldn't be served well with a panel of 3 magistrates. A final point on the courts is that there are tribunals. Tribunals are an independent part of the system in England and Wales, and they often deal with specialised disputes. So, for example, you've got the Employment Tribunal, and the Employment Tribunal deals with any issues that arise between the employer and his employees. And the tribunal process is a lot less complicated and a lot less formal than what would be the case in a court. But you might be wondering, well, how does it all fit together? How does this hierarchy operate in practice? For example, to what extent is a lower court bound by the decision of a high court? And this is where we have to think about what is known as ratio decidendi. So when a judgment is given, it will usually contain the facts of the case, it will contain the issues that came up, it will contain maybe some of the arguments that were given that the judge wishes to refer to. It'll also then give the decision of the court, but it'll also give its reason for the decision. And that's what is known as the ratio decidendi, the reason why they have come to this particular outcome. And normally that ratio is binding on lower courts. Lower courts can't overrule a decision of a higher court. Parties might claim that ratio was misguided and try to appeal that case to a higher court. And they could ask the higher court to reverse the decision of the lower court. That's one option. Another option is to have the ratio overruled. So if a decision was made back in 2010 and 5 years later the parties are not happy with that because they want to argue a particular point and they want to argue that that case was wrongly decided, they could attempt to argue that that case should be overruled, and that's one way a ratio can be overruled. Another aspect to think about also is what is known as obiter dicta. An obiter dicta are other things said by the judge in a judgment. So they'll be discussing the issues, and they maybe want to discuss something hypothetically, or to discuss another legal issue that comes up that's not the main issue in the judgment, but is relevant to the discussion that they want to have. And that is generally what is known as persuasive precedent. What that means is no court is bound by it, but the courts in the future could decide to follow it and could decide to apply it as ratio, as part of the main reason for the decision. So what I just wanted to do in this video, it was to just give you a bit of an overview of the court system. It is quite technical, but it's quite interesting. To be able to see how the court hierarchy works and to see what kind of cases each of the courts deal with. And one of the great things that you can do, although not at the moment due to the current situation, is to be able to visit courts and actually sit in on the cases. So you can go to your local magistrate court or Crown Court, or you can go to the Supreme Court or the Royal Courts of Justice and actually sit in on cases and hear the cases, hear the judges, hear the arguments being made. And even if you're not interested in the law, it's a good opportunity to see how a court works and to see the law in action and get to see what works on the ground, how things work in practice. So I hope you found this video interesting, informative, or just something to listen to or to watch. If you have enjoyed this video, don't forget to give it a like. Make sure you subscribe to the channel. There are some fantastic videos on this channel, opportunity to learn something new or just something to enjoy. I really recommend you subscribing. Comment if you've got any questions or queries. I'll try and answer them if I am able to. But also check out my channel as well. You'll find the links in the description below to my channel, to my Facebook and Instagram account as well. Subscribe to that as well. I do content about life at Cambridge, but also content about the law, what I'm getting up to, things like that. Hope you have enjoyed this video and hope to see you soon.